Let's talk about running a canine around a car that's parked in a parking lot where the driver has walked away briskly. My name is Anthony Bandiero. I'm an attorney and senior legal instructor for Blue Gold Law Enforcement Training, bringing you a roadside chat. This question comes from an officer in Okie, Oklahoma. Okay, Oklahoma is okay. That's the motto of the state. I think it's like it's not a great state, it's not a bad state. It's just an okay state. So that's what it says. Oklahoma is okay. So, an officer was following a car that was acting suspicious. At the time, the officer wasn't able to get traffic on the vehicle. So, okay, he's driving 10 and 2. The driver was known as a drug user, dealer, and eventually parked his car in a parking lot. The driver got out of the car and walked away from the police. The driver appeared he did not want anything to do with the vehicle due to hiding in a creek. So I guess he hiding in a creek, that's pretty humorous. A canine was eventually brought over to the vehicle where it was parked in the parking lot, and the handler conducted a free air sniff. The canine alerted on the vehicle. Officers were not able to get the keys from the mail because by the time once the alert occurred, they started looking for him, and he was MIA. The officers were able to unlock the car. They probably jimmied it somehow, and they found a lot of narcotics. The question is, should officers got a search warrant after the canine alerted, or were they okay in Oklahoma to unlock the car and search it? The answer is very, very clear here, and the answer is good to go. The Supreme Court has made it crystal clear that probable cause to search a vehicle does not require a warrant. What we teach here at Blue to Gold is 4 things. Number 1, do you have probable cause? When a canine alerts to a vehicle, does that give you probable cause? The answer is yes. Canines are reliable. You know, you have to have training records and be able to testify to this and so forth. But the Supreme Court has decided this case. I believe the case was Florida v. Harris. That canines are reliable. They talked about record requirements and so forth. Their reliability is essentially based on totality of circumstances and so forth. The next thing is not on curtilage. This vehicle is in a parking lot. That's not curtilage. Even if the vehicle was in an apartment parking lot, it would still not be curtilage in 99% of the cases. The third issue is the vehicle mobile. Well, clearly the guy was just driving it. And the fourth issue is you search it as if you had a warrant. That's U.S. versus Ross, Supreme Court, where you search it no more intrusively or less intrusively than if you had a warrant. Therefore, if you did take the time to go get paper, to go get a judge's signature, and he gave you a warrant for the car, what would the warrant allow you to do? It would allow you to pretty much search the entire car where drugs could be found. That's a drug warrant is a very intrusive search. Therefore, there's no fifth. There's no, I can get a warrant if there's time. Clearly, that's not part of the motor vehicle exception. Also, we have tons and tons of cases where vehicles have been searched where there's no access by the driver because they're either A, in handcuffs in the back of the police car, or the people are not on scene because they left or whatever. There is no occupant requirement under the motor vehicle exception. That is crystal clear, clear as day. A case, 1984 case called Thomas, U.S. Supreme Court had made that almost crystal clear. In some ways, they're like slapping around the lower courts because they just were not paying attention in school when the Supreme Court said you don't need any agency whatsoever to search these vehicles. However, with that said, just because you can doesn't mean you should, right? So are there times where you should get a warrant? Sure. Is this one of those times? I don't know. Probably not. But not. I'd probably just search it because because I just have so much confidence in this area, and I just know what the Supreme Court wants from us. And I also know that Oklahoma is fine. 10th Circuit is fine. But all circuits are fine. It's a federal issue. But the states can be more restrictive, like Washington and New Jersey and Pennsylvania, New Mexico, and so forth. But in this case, I don't really see a compelling reason to go stop what you're doing and go get a warrant. If this was a cartel case, maybe that's worth it. Just because there might be some more litigation, especially when you find 100 kilos of coke. If this was a murder case, certainly go get the warrant. If you're going to do forensics, go get the warrant, right? But if you just want to go open a guy's car door and just go grab the dope that's somewhere in that car and leave, I personally don't have an issue with it. The law is very clear here. I hope this has helped you get it right every single time. If you like what we're doing here at Blue to Gold, like, subscribe, share with your friends. And until next time, my friends, you stay safe.